housekeeping item. I don't know how you want to handle this.
Oh.
Gary and I, yeah, we just conferred during the break with respect to the signed final report, because there was an issue. I had not put the signed copy in our exhibit book. So we agreed that we can either just substitute the signature page or swap out the document, which is city's exhibit 5.
So we have to sign the signature page now?
Yes, sir. And we agreed that we could just substitute that.
Yeah,
page there.
let's do that then.
Okay.
Yeah.
I just have one at the moment. Maybe I'll give it to.
Okay.
If
Gary,
you give it to the
you
arbitrator.
could get us 4 copies of this document, maybe a whole bunch too. We could get it that way.
See the last page.
The rest is the same, right?
Yeah.
You have the cover over there too.
Same as you. pages.
4 copies.
Four copies, and you can hold it till next break, and then we'll get it in the exhibit notebooks.
And
Okay.
carry whole punch too if you could.
Yes.
Thank you.
Thank you very much.
On the top or on the sides? Oh, for your 3
Sides.
rooms?
Yeah,
Yes, ma'am.
Great. Thank you. No, that's 45. What you decide on closing?
We're not going to do those.
Okay, good.
We'll reserve this for the break.
Okay, great. Ready to proceed then?
Yes, sir.
Okay, Madam Stinson, let's go back on the record. Lieutenant Mathis, you're still under oath, you're still on cross, and Mr. Wilson is still asking you questions. Lieutenant Mallon, that's all right.
Lieutenant Nick Mathis, you know who that person is, correct? And he's still employed with this agency? It's my understanding from the IA that you interviewed him 3 times, is that correct? Okay. And he was the supervisor of Officer Goins, that Officer Goins called that evening shortly after the encounter with Mr. Staff, correct? Okay. Do you seek to make sure that the IA report is complete and accurate? I know we spent time before the lunch break going through various drafts and redrafts, and then we got to a final version of the report, which is your July 11, 2019 report. Is that correct? Now, one thing we haven't talked about, and that is the transcripts in these proceedings. In City's Exhibit 10, in the black notebook, I believe you'll see that that is the transcripts of Officer Mathis, or Lieutenant Mathis's interviews. Is that correct? Yes, sir. Now, one thing that I think, would you agree that is consistent, and we've seen other transcripts of this proceeding, when you go to the last page, there is no notary or sworn to section for these transcripts. Is that correct? That's correct. So what we are to rely upon is that the transcript is an accurate representation of what's on the audio, correct? Yes, sir. Do you believe that that was the case in this particular IA for Officer Goins? That the transcripts that have been provided in this case match the audio? Yes, sir. What steps, if any, do you take as the IA investigator to make sure that the transcript and the audios match one another?
I actually watched the body cams, and you talk about the transcripts when we did the audio. I listened to the audio, and then I handed it over to
Ms. Ackerman? Once you receive back the transcripts from Ms. Ackerman, do you ever listen to the audio to see if they match the transcript?
Not typically.
Yes, sir.
Like I said, I listened to the transcripts before I even forwarded that to Rebecca.
Okay. The reason I'm asking is, are you aware that there is a portion on the audio of the 3rd interview of Lieutenant Mathis that is missing from the transcript? I'm sorry? Are you aware that there is a portion of the transcript that does not include something that's on the audio interview?
Yes, sir.
Are you aware that there was a section of silence on the audio of one of the interviews of Lieutenant
No,
Mathis?
sir.
The reason I'm asking this is, do you recall just before the break, that one of the documents we looked at, I think it was City's Exhibit 15, was the email from Chief Umberger to Batten about should something be omitted? You remember that?
Yes, sir.
And it was in reference to something about Lieutenant Mathis, correct?
Yes, sir.
I want to play you a portion of the audio interview, and then we'll look at Exhibit 10, the third interview.
Lieutenant Brown from the Baton Police Department. Today is Friday, June 7, 2019. Time is approximately 3 p.m. This interview is in reference to Internal Affairs Investigation 19-3. And present with me today is Lieutenant Mathis, Brian Burka.
I'm going to draw it all the way over to the 4-minute, 53-second mark.
Unless there's something questionable, when I review it, how can we put it on the record?
Now there's silence at about the 4:58 mark, continuing. Okay, the first time we hear you, that's you saying, correct?
Yes, sir.
At the 5:25 mark of the third, this is the June 7th, 2019 interview of Lieutenant Mathis, okay?
Okay.
Ironically, that's also the day, the second interview of Officer Goins.
Okay.
You aware of that?
Yes, sir.
Any reason to dispute that?
Yes, sir.
Okay. So, let me back it up again, just at 4:53. 4:50 right now.
How can we put it on the record?
Okay, the last words we heard were something about the body cam. Did you hear that?
I do not.
Okay, let me play it again. And this is Lieutenant Mathis speaking.
Could you go back further to give me some context at least?
Okay. I'll go to the
For
four,
what they're talking about?
go to the 4-minute mark.
His body camera was there and his vehicle was there, correct?
Yes.
Would you have been able to, do you know how to view that?
I'm pausing it here only because if you will turn in Exhibit 10, turn to Exhibit 10 in the black notebook. You should, if you're at the third interview, I wish I could tell you what page number, because they're numbered 1, 2, it's like one interview is 6 pages, then it starts renumbering again. So when you get to about the 10th page of the document, what minute, or maybe, you see one that says June 7, 2019?
Yes.
Okay, now turn ahead, or even behind it, by 2 pages.
Page 3.
Yes, sir, go to page 3. Actually, I'm sorry, leave it on page 2. Leave it on page 2. And I'm going to see if I can track, we can all just watch the video and the transcript here.
That video at that time with his computer.
Okay. As long as he logs in, logs in password and all that, but
Okay, so there's a password in there that he has to put in before you get to view.
yeah, he has to log into Axon.
Okay, did you see at the bottom of the page here? Yes, he has to log into Axon. Okay?
Yes, sir.
Now, I'm going to turn it back on, so We're at the 4:34 mark.
Did you have time that night to do that?
It wasn't something we don't put John under arrest unless there's something questionable, when we go back there and then we review body camera footage. But unless there's something questionable, we're not reviewing body camera footage under arrest.
Yeah, I'm pausing it there because it's at this moment. You see where the transcript seems to track the audio, correct?
Yes.
Now we're going to begin the long pause. 4:53. Okay, at the 5:24, 5:25 mark, you say correct?
Yes, sir.
So for that roughly 32 seconds there, do you have any idea what was said during that 32 seconds?
There wasn't anything said.
Okay? If there was a break, like someone needed to go to the restroom or something, isn't it true that you've been trained under the Officer Bill of Rights that all recess periods are to be recorded as well?
Yes, sir.
We discussed, what made you believe that Officer Goins beat up his camera did not?
So it's your testimony that those 32 seconds were simply, it was just a long pause, that no one was speaking?
Yes, sir.
Thank you for letting me ask me to play that so you could give us an explanation, because obviously I haven't had a chance to talk with you about this till today, correct? All right. Along those same lines, though, you did tell us yesterday that you had a conversation with Assistant State Attorney Amy Walker, correct?
Yes, sir.
And she's the one that we see that there was a I believe a no information entered into this case, correct? Did you include anything in your IA report about your conversation with Assistant State Attorney Amy Walker?
Yes, sir.
And do you know where that is included?
You
Give your report.
City tab 5.
Should be city tab. Thank you, Al. And for the record, the ASA no information is behind tab 4 of our notebook if you needed to see it.
Page 4.
I see it at the bottom of page 4.
Yes, sir.
Okay, you do provide, I see at the bottom of page 4 of City Exhibit 5, a recount or summary of your conversation with Assistant State Attorney Walker, correct?
Correct.
However, you didn't include any statement from her, a sworn statement, or certainly you didn't interview her, correct?
I did not.
And I know you mentioned yesterday as well that this case was null pros or no information, and you understand what that means?
Yes, sir.
And essentially, as your understanding, the state attorney decided to drop the charges against Mr. Staff.
Correct.
Now, simply because charges are dropped by a state attorney does not necessarily mean that it was an illegal search, though, does it?
Could you phrase the question again?
Yeah. Simply because charges were dropped or not pursued by a state attorney does not necessarily mean that it was an illegal search, correct?
Why else would they not drop? Why else would they drop?
Haven't you, in your police experience, had situations where the state attorney decided not to pursue charges for one reason or another?
Yes, sir.
And those can be in situations where you've even done everything by the book, correct?
Yes, sir.
I mean, you haven't, there's no issue of an illegal search or anything like that, and you still have had charges dropped before.
Yes, sir.
Now, I know you came to an ultimate conclusion that you believed Officer Goins was untruthful about his account of what he saw that evening, correct?
Correct.
Prior to your involvement in this investigation, you never had any reason to doubt the character for honesty or truthfulness of Officer Goins, did you?
No, sir.
Did you look into anything in his past, like from his experience at the DOC, Department of Corrections, to see if there had been any prior allegations against him?
If I'm not mistaken, I did his background investigation. I was the supervisor at the time.
And you didn't find anything that would lead you to conclude that this is an officer that's ever had his character for truthfulness questioned, is that correct?
Yes, sir.
I mean, you agree with
I
that?
agree.
Do you have any independent recollection as you sit here today of removing anything from your report at the request of Deputy Chief Batten or Chief Humberger?
I do not.
Now, were you asked at some point, sir, to, well, before we get there, I'm sorry. I do want to cover one other area about the arrest that night, or the detention/arrest of Mr. Staff. You claimed in your testimony yesterday that Joseph Staff was lawfully detained by officers Goins and LaFleur when he was secured in handcuffs. Is that correct?
Yes, sir.
Do you still agree with that?
Yes, sir.
So if you believe that Officer Goins had seen, I know you don't believe this, but if you, assuming for the moment you believe Officer Goins' version, that he had seen Mr. Staff resisting while being detained, an arrest for resisting would have been permissible, correct?
Yes.
And I believe yesterday you told us that a defendant must be under arrest to be charged with resisting arrest without violence. Is that correct?
Doesn't have to be under arrest. I didn't say that he has to be under arrest in order to charge him with resisting arrest.
Okay. He doesn't have to be under arrest?
No.
Okay. Because isn't it true that the statute in Florida permits an officer to arrest someone who is interfering in the lawful execution of their duties as a law enforcement officer?
Yes.
If you would turn to tab 39. This has already been admitted into evidence, sir. This is the Florida resisting without violence statute. Do you see that, sir?
I agree.
And you agree that it does include near the end of this paragraph it has the words, or in the lawful execution of any legal duty.
Yes, sir.
So would you agree that there is nothing within the definition to describe what resisting is, and that it's therefore left up to the discretion of the officer?
It is.
So this just comes with an officer's experience to know what he or she believes is resisting in a particular situation.
Correct.
Okay. Now, to make a warrantless arrest on a misdemeanor, the misdemeanor in question, there has to be an exception, right?
Yes.
And there are misdemeanor exceptions in the state of Florida. Is
Yes,
that
sir.
correct?
Correct.
Are you aware that in fact, that, from what I found, there's 22 types of offenses that qualify as exceptions to Florida's warrantless arrest rule, and one of those is disorderly conduct on the premises of a licensed establishment.
Yes.
Is that one of them, sir?
Yes.
Okay. 'Cause maybe I misunderstood, but it seemed like Mr. DeRozier yesterday was trying to get you to agree that an officer could not arrest for disorderly conduct at a licensed establishment unless the officer saw it happen with their own eyes.
So to clarify this,
Yes, sir.
Okay. It has been said by the state attorney's office that they would not prosecute any of the charges of disorderly conduct unless the officer is present. There's additional people to it, where there's other witnesses. That's what was said. It was been past practice for the last, I don't know, 10 years.
Okay.
Where they actually told us that if we made an arrest solely on somebody else's word, that they wouldn't move forward with the prosecution. So I understand that the statute says that one thing, but we were told by the state attorney's office that if we did make an arrest, that they wouldn't ask to prosecute.
You were told by the state attorney's office here in Volusia County
Correct.
that the officer needs to see the disorderly conduct?
Yes, sir.
So
That they
just
wouldn't move forward with it.
So just like in the video we see of the two patrons there, the two men, it's your understanding that even though it may meet the statute, the Volusia County state attorney's office is saying they don't want a disorderly arrest to come into their office unless the officer saw it.
Correct. Whether it was in the presence of the law enforcement officer, and that the fact that an officer cannot file just the charges of disorderly conduct based on his observation, there had to be other.
Okay, thank you for that clarification. So it's not so much that what the law said. I mean, the Volusia County, I keep wanting to say sheriff's office, the Volusia County State Attorney's Office has a practice or policy in place that they've communicated to the DeLand Police Department, is what you're telling me.
Correct.
Okay. And isn't it also true, Lieutenant Milan, that when other charges exist for an arrest for disorderly conduct, there's no prohibition from additionally charging the defendant with a misdemeanor that did not occur in the officer's presence?
Could you repeat that again?
Yeah. Isn't it true that when there are other charges
Okay.
for an arrest, nothing prohibits the officer from charging the defendant with the misdemeanor of disorderly conduct, even if it didn't occur in their presence?
Yes, sir.
So you would agree with that?
Yes.
And isn't it true that Officer Goins and LaFleur claim that the misdemeanor was not the basis for the case of the arrest of Mr. Staff? In fact, remember when I showed you the portion of Officer LaFleur's testimony where he said he was going to arrest him for the resisting charge?
Yes.
Okay, it had nothing to do with the narcotics or certainly with the disorderly conduct? Do you recall that, sir?
I recall that.
Okay. And just one other thing about something you communicated yesterday that I want to ask about. You said that it's common practice for the arresting officer to communicate all charges via radio to Central Dispatch. Do you remember?
We normally call out what the initial arrest is for.
Are you aware of any DeLand Police Department policy that details that requirement? By that I mean that an officer is supposed to list everything that they're going to charge a suspect with.
No.
Because haven't you observed it to really be the fact that an officer may call out for CAD purposes through dispatch only a charge or two charges, but then have other charges identified on an arrest report.
And again, normally is what the cause of the cause for the arrest. So normally when we call out, we have 1015 for disorderly conduct, and then you ask for the additional. But normally that's how we actually call it out. We call out, we have 1015 for whatever this case may be.
So you call it out, but you may not list every charge you're going to charge a person.
Correct, just the initial charge.
Okay. Because I thought, and I appreciate you clarifying that, because I thought yesterday you said the officer literally calls out every single charge.
No, sir. I'm saying that the initial reason for the arrest.
Okay. You recall yesterday being asked about Officer Goins never issuing a Mirandizing Mr. Staff, giving his Miranda rights. I'm sorry, you need to answer all of this.
Yes, sir, I'm sorry.
Okay. And of course, you Mirandize someone when you place them under arrest, correct?
Not necessarily.
Okay. So the fact that you didn't see Officer Goins on the BWC issue a the Miranda rights to Mr. Staff, that does not necessarily indicate to you that he did not believe he was under arrest, does it?
Right, you don't always have to, I mean, it depends. You don't have to always read Miranda. It's just when they're arrested, obviously. When you detain somebody and you're about to ask them questions in reference to the crime they might have committed, they have to be able to be Mirandized in order for that to be used in court.
You recall answering Mr. Rozier's question yesterday, and I believe you said, if someone's being interrogated, even a custodial interrogation, they need to be Mirandized. Do you remember that?
Yes.
And did you feel that the questions that Officer Goins was asking of Mr. Staff rose to that level?
I would have to look back to see what questions exactly he asked.
Okay. Would it help? I mean, I can play the video again from his BWC if you want to hear his interaction with Mr. Staff. Would that help you, Andrew?
Sure.
Okay. The record, I played you the video, I'm sorry, the BWC, at least a portion of it, of Officer LaFleur, and now we'll play Officer Goins. And I may pause and ask you some questions during this, okay?
Yes, sir.
By the way, this is probably a good time for me to ask you, since I haven't yet. Now, if Officer Goins was wearing his BWC in the sternum area of his chest, would that be kind of consistent with what you think we're seeing here, while we're seeing his steering wheel and just sort of the top of his dash?
Yes, sir.
Okay. And by the way, just in case the arbitrator, Mr. Finnegan, is not a law enforcement officer, nor am I, just to remove any doubt, there's nothing wrong that his audio is not on right now, correct?
That's correct.
In fact, the audio only goes on once you engage with someone in the public, right?
No, sir, it actually activates 30 seconds after you actually
Okay.
initially react.
So it's got an auto, it goes on automatically 30 seconds.
Correct.
Okay. Would you agree with me as we're, after we're seeing the BWC of Officer Goins here, that it appears that, you can't see his speedometer, correct?
Correct.
You can't see over the dash very well. Would you agree with that?
Agreed.
All we are seeing as the eyes, if you will, I mean, we're essentially the BWC, right? We're his camera right now. This is what we're seeing.
Yes.
So would you agree that obviously the distance from his BWC to his eyes, whatever distance that is for Mr. Goins, would be how much better he could see above his steering wheel and dash?
Yes.
Okay. And you agree, we're already seeing the aura or pinkish hue of red and blue lights, correct?
Correct.
And he pulls over in the opposite direction of the flow of traffic to get behind Officer LaFleur's car, correct?
Correct.
So if it came on 30 seconds after he activated it, I guess by rough math, we're looking at 50, 55, 45? Take 30 seconds off there? Is that right? We're at 5:56:15, right?
Correct.
So 5:55, 45. Okay. And now you'll hear his interaction.
No, I didn't. Come over here. Listen. I want you to talk. Yeah. How much have you had to drink tonight? Nothing, man. Nothing? Have you already on any medication or any type of drugs? Because you're acting impaired. We just want to make for your well-being is what we're worried about. Have you been drinking? You smell like it. No. You haven't had anything to drink? No. Where were you coming from? Dude, I just came from there.
Okay, is any of this, let's assume for the moment that as you've heard Officer Goins and you know his story, he has told you under oath that he believed that Mr. Staff was under arrest at this time, correct?
Yes.
Okay. So is there anything inappropriate with the type of questions based on your police understanding about Miranda at this point? And by the way, if Officer Goins believed, as he has testified he believed, that Mr. Staff was already under arrest, wouldn't it be reasonable to assume that if a Miranda rights were issued, they would have been issued by Officer LaFleur?
Can you repeat that one more time?
Yes. Since Officer LaFleur was the first officer on the scene, correct?
Yes.
Officer LaFleur is the one that put him in cuffs, correct? Officer LaFleur is the one that walked him over to Officer Goins. If Miranda rights were to have been deemed necessary, wouldn't it be reasonable for Officer Goins to assume that Officer LaFleur issued the Miranda warning?
No, sir.
Why not?
Because we don't assume that somebody actually read the Miranda rights, because if that officer starts asking questions, and he is under arrest, and they have Miranda rights, anything that he actually says can't be used in court.
The only reason I'm raising Miranda is because Mr. DeRosa raised it yesterday, wondering about if Miranda rights have been issued. And my question is to you, is there anything unreasonable for an officer to believe if someone's already under arrest that they would need to be Mirandized the second time?
Would it be unreasonable?
Yeah. Do you have to Mirandize somebody twice?
It all depends on whether the person actually says that he doesn't want to talk.
When one officer hands off another suspect to another officer, do they have to re-Mirandize them? If they believe they've already been Mirandized? Well, if they believe they've already been Mirandized, do they have to do it again?
Well, you just can't assume that they believe that the officer can't just assume that that officer read them with the Miranda rights. Is that what you're getting at?
You wrote various versions of this report in your own words where you said you believe that this was just a case of some miscommunication and false assumptions, right?
I did.
So I'm using your own words from your earlier drafts of your report. Wouldn't it have been reasonable for Officer Goins to assume that if Miranda was even required, which you can't tell us in your own words whether you think it even was, that Officer LaFleur would have already Mirandized her.
I'm not gonna say whether he actually assumed or not, I don't know. He assumed.
But you were not expecting that, for anything we've seen so far, that Officer Goins had to Mirandize Mr. Staff, correct?
What's there? Yeah, what? Hey, unlock your car, because I'm gonna put them in it once we're done. I'm just gonna secure you right now. We're trying to figure out what's going on. That's fine. All right?
Now, when you secure someone, aren't you supposed to, for officer safety, as well as the safety of the suspect or detainee, if they have a weapon that can be reasonably seen in their pants, to remove it?
Yes, sir.
Okay. So is there anything wrong with Officer Goins removing the knife from his front pocket?
No, sir.
I'm gonna be honest with you, that's why. I'm telling you everything. I'm Officer Goins again. You got anything in your boots? Huh?
Okay. He's doing you see his hand here patting down the sock or shoe of Mr. Staff?
Yes, sir.
Anything wrong with that?
Yes, sir.
So everything's still by the book so far, correct?
Yes, sir.
No extra knives, nothing?
Now, he says extra knives. Did you notice that?
Yes, sir.
Isn't that consistent with the fact that he's already removed the knife from him?
Yes, sir.
Otherwise, it doesn't make sense to use the word extra, does it?
Correct.
We're trying to figure out. They're saying you're up here trying to cause a fight.
Okay, I think we just saw the wallet placed on the front. Did you see that? And is there anything wrong with that?
It's face the pat down, and he's not under arrest. You cannot just go into his pockets and retrieve anything. Your pat down is specifically for weapons.
Okay. But if he believed he was under arrest already, that would have been okay to take the wallet.
Yes.
So again, we're getting back to assumptions. As you wrote in your mini drafts before your final report, you felt at one point this was just a case of maybe some miscommunication and false assumptions, correct?
Correct.
Such as Officer Goins falsely assuming, perhaps, that Mr. Staff was under arrest when maybe he wasn't, correct? And that can be an honest mistake for a rookie officer, correct?
It can.
What's going on? What happened? Somebody talking trash to you? Walking by? Were you trying to at the bar?
Anything inappropriate with these questions? He's just doing a field collecting of information as an officer does in the field, correct?
I don't know who you are. Who are you? What's your name?
My name is Joe, man.
Gerald or Joe?
No, my name is Joe.
Joe?
Come on, dude.
Okay, right now you're just secured. You're under arrest.
Dude, what the fuck happened here?
Well, you tell me.
Okay, and you see he reaches down, and there's one of the bags of cocaine, right? Little tiny bag, right? And are you aware that the testimony is that it must have come out when his wallet came out?
Correct.
But there's no way to see on this video how it exactly got on the ground, is there? At least from this video.
Correct.
I mean, if you're the investigator looking at this, do you even know if it possibly, if there's some way, if his hands are behind his back, right? He's cuffed behind his back. Correct?
Correct.
I'm kind of, for the record, I've got my hands crossed on my back. I'm going to cross them right here. Can someone still reach in their own pocket? Look, as I'm doing here, is it possible when you're cuffed behind your back to still reach in your own back pocket? It's possible. Was there ever any thought given that maybe this guy knew exactly where his cocaine was and tried to drop it on the ground?
It wasn't because of the comment that woman made at the time
He says he found it, right?
in his pocket.
Yeah.
Yo, man. Like, what are you gonna do? You want
Well, right now, you're going to be under arrest for narcotics that I found in your back pocket.
What do you mean?
that be because the guy reached in and fumbled around with it and they fell out?
I see him fumbling around, I'm sure.
Okay, precisely. You can't see it on this video, can you? There's things that we'll never be able to see on this video. Agreed?
Correct.
So you had to make some assumptions too, didn't you?
And based on what Officer Goins said, he took it out of his back pocket.
Hey, I will stop resisting. Don't pull up. Hey, 27? I get a narcotics on me. This guy cocaine in his back pocket. Step in the back of the car.
Is it still permissible, in your opinion, for the questions that he's, or the dialogue he's having with Mr. Staff?
Yes.
Okay. So, and to clarify though, you believe that what was improper in terms of the policing technique was Officer Goins reaching in to get his wallet out and finding the cocaine in his back pocket?
Yes, sir.
Okay. And you recall there being some dialogue in one of your interviews with Officer Goins about his use of terminology from 10 plus years with DOC and only 9 months on the job at DeLand and using the words pat and search interchangeably?
Yes.
Okay. Did you find that to be a credible, honest explanation?
Could have been,
Okay.
but we are trained the difference between a pat down and a search.
Sure. And I believe you told us earlier, you weren't perfect as a rookie cop either, correct? Let me go back over here to wrap up now. Just checking those here. Just want to go through a couple of exhibits to wrap up here, sir, to have them into evidence. I think we left off with exhibit 15, for the lunch break.
That's correct.
Thank you. If you'll turn to tab 16, I just want to see if you recognize this, sir. I know you're not copied on this email, but tell me if you have seen this before.
I have not.
Okay. And Prudence Dice, is that a lieutenant here in the department?
He's a captain.
Captain?
Yes, sir.
Okay, so this is a email of July 3rd from former Deputy Chief Gary Batten to Chief Umberger and Captain Dice, correct?
I'm sorry?
This is an email from former Deputy Chief Gary Batten to Chief Umberger and Captain Dice.
Yes, sir.
And it looks like Deputy Chief Gary Batten is saying he removed the timelines that Juan initially referred to as in the big picture. They were confusing and irrelevant to supporting or mitigation, or I guess he meant mitigating or mitigation the concerns. Do you see that, sir?
I do see that.
So would you agree this appears as though Deputy Chief Batten is acknowledging that he took some things out of your report?
Yes, sir.
All right. Just briefly, if you'll look at, turn 2 pages ahead. Again, there's some things that are in red and some things that are highlighted in yellow. Are these your changes, sir? Or additions? Those that are in red and yellow?
Yes, sir.
Again, did you author this report?
I was the one that completed this report, yes. I was the one that started it.
All right, I think where we may find that the deputy chief removed some things, if you'll turn to page 15 at the bottom. You see at the top of the page, it says the following timeframes indicate some discrepancies.
Yes, sir.
And then there's 3 red bullet points that have been removed.
Yes, sir.
Did you do that, or did the deputy chief?
I wrote it, he actually said that that's not, you know, he must have marked it off saying that that's not necessary.
Turn to the very next page, and this is one that I want to ask you about. Near the bottom of page 16. By the way, I don't know whose asterisk mark that is in pen. Do you know?
I have no idea.
But would you agree that a sentence that has been struck through reads that it should also be noted that Officer LaFleur and Officer Goins had both agreed that the subject resisted during the initial contact, which was documented in the first 45 seconds of the VWC?
Yes, sir.
So a sentence that supports, strike that. That sentence supports what Officer Goins told you, correct? That the subject, Mr. Staff, was resisting.
Correct.
And that's been removed, or that someone has decided to remove that sentence, correct?
I think we've actually mentioned that a couple of times.
Okay. Is that you striking through this sentence?
No, sir.
Do you know who did?
I couldn't tell you exactly who did. I would imagine either Officer Vasquez or Deputy Chief Back.
Okay. Could it have been Chief Umberger, because this email is addressed to him?
No, sir.
Okay, just a couple more pages. Go to page 20. Do you see those other entries that are highlighted and have been struck through on page 20?
Yes, sir.
And that also includes another sentence about Officers LaFleur and Goins agreeing that the subject resisted during the initial contact, correct?
Yes, sir.
Go to page 23, just for one question here. There's a sentence in red, and again, it has an asterisk. Do you know, when I say asterisk, do you know whose handwriting that is?
No.
Okay. Well, in red, there's a sentence added. I guess it's been added. Do we agree that anything in red has been added?
Or highlighted, yes, sir.
And that sentence reads, would you agree LaFleur also walked staff into a recessed alcove at the time he was handcuffed, which would have further obstructed Goins' view? You see that, sir?
I do.
Did you add that, sir?
It had to be me.
Okay, turn a few pages behind it. We have an email from Jason Umberger. The very last page of this 16.
Okay.
Actually, I'm sorry. It's a duplicate of what's behind the next tab, so just pull that out if you want to. I see that we have that in the very next, behind the next tab. So at this time, I'd like to move into evidence what's been marked as Exhibit 16.
No objection.
Exhibit 16 has been
And I know, if you turn to 17, sir, I know you're not on this email again, but I just want to ask if you have any knowledge of it. Have you ever seen this email exchange between former Deputy Chief Gary Batten and Chief Umberger on July 3rd and 4th
No, sir.
of 2019?
No, sir.
You see in the third paragraph on the July 4th email from the chief, he tells Deputy Chief Batten, and then make sure everywhere it states the same thing about whether or not LaFleur or Goins called in, they, quote, had one secured, close quotes. Do you see that, sir?
I see that.
One place it says LaFleur called it in, and the other place it says Goins did. Not sure who did. You see that, sir?
Yes, sir.
So you see the chief here instructing Batten to make sure there's something in the IA report that he's not even authoring.
Yes, sir.
Okay. At this time, I'd like to move into evidence with remark as Exhibit 17.
No objection.
Exhibit 17 submitted.
Sir, turn to tab 18. This is an cover email with a report behind it from Gary Batten and Jason Umberger. Again, I know you're not copied on this. Have you seen this email before, sir?
No, sir.
And you agree that the first sentence says, I made the changes that you pointed out in your email?
Where's that? I'm sorry.
The first sentence, Chief, I made the changes that you
Oh,
pointed
yes,
out in
sir.
your
Yes,
email.
sir.
You see that, sir?
I did.
Were those changes that were requested ever communicated back to you?
Anytime I had to make some changes, I spoke to the chief back, and we discussed the reason why I was going to make any changes to my report. You know, he would tell me that it read wrong, or it was just grammatically wrong, or just didn't flow right. So he would actually suggest maybe putting, making some changes.
All right, and then there's a version of the report behind it here, sir. Again, is this still your report that you are
Yes, sir.
contending is yours?
Yes, sir.